Filibuster. You have to be a real geek to know about these rules and why it is he's allowed to be doing what he's doing, running down a clock. Technically, this is not a filibuster at all. We're going to get to that in just a moment. But first, I want you to hear a sampling of this man, Ted Cruz, what he has to say, and then try to figure out as he's saying it, why he's saying it.
I will credit my father. He invented, this wasn't for the restaurant, but he did it anyway. He invented green eggs and ham. Some time ago, I tweeted a speech that Ashton Kutcher gave. Now, number one, just as a consumer, I'm a big fan of eating White Castle burgers. I don't believe there's been a day on this Senate floor that I haven't worn my argument boots. I took the coward's way out, and so went and purchased some black tennis shoes. And so I am not in my argument boots. I want to take the opportunity to read 2 bedtime stories to my girls. I do so like green eggs and ham. Thank you, Sam I am. So I want to point out just a few words of wisdom from Duck Dynasty. You put 5 rednecks on a mower, it's going to be epic. Redneck rule number 1. Most things can be fixed with duct tape and extension cords. Happy, happy, happy.
Can you tell me, Senator Cruz, where do Chinese gooseberries come from?
Chinese gooseberries actually come from New Zealand.
Can you tell me what part of the world the Panama hat comes from?
Ecuador.
A camel's hair brush. Do you know what it's made of?
Squirrel fur. A third observation about Senator Rubio's question. When he compared Obamacare to a horror film, I enjoyed that comparison. In fact, in my mind, I heard the music from The Shining, or not The Shining, from Psycho, in the shower scene.
How are you doing?
I thank the senator from Kansas, and I will tell you I am doing fabulous. Ms. Saldana, you are a Texan. You were a prosecutor in our state. You had a good reputation as a prosecutor. But you're serving in an administration that consistently refuses to follow the law. And we heard this morning the very real consequences of that. Now, in March, when you were testifying before the House, you were asked about sanctuary cities. Cities like San Francisco that defy federal law, and because of their defiance of federal law, Kate Steinle is no longer with us. She was murdered because of the refusal of local officials to recognize federal law. You were asked in that House hearing, should federal law compel state officials to comply with federal law? And your answer, and I want to quote verbatim, was thank you, amen, yes. Now, in my view, that was the former federal prosecutor speaking and giving an answer, and yet the next day, you issued a statement retracting what you'd said and saying, in fact, although you'd said amen, which is a pretty powerful statement from the heart, you didn't in fact mean that federal law should force local officials to comply with federal laws. I want to ask you, what political officials pressured you to change your statement?
Not a single one. This came from, the original statement came from my heart. The clarification came from our heart. And I don't mean to quibble with you, Senator. I respect you greatly. But I will say this. The question was not asked. The question was very specific. Would it be helpful for detainers to be mandatory? The law enforcement response there is clarity is always helpful. But I wanted to be sure that people were not reacting to that as an indictment of PEP or working with communities, and that's what I'm committed to do.
So let me make sure I understand your testimony correctly then. You said then it would be helpful, as in presumably helpful is good, is beneficial, is something you support. So are you saying then that ICE supports making it mandatory to comply with federal detainers?
No.
So it's helpful, but you don't support it.
Well, no, sir. I support what we have proposed and what we've been spending
you just said
many
it's
hours
helpful.
on.
You
Yes,
just said
sir.
it's, but you don't support it.
Clarity is always helpful, but cooperation and working with our state and local partners, something I've always done. I will continue to do it, and I'm committed to see it through with respect to these jurisdictions that haven't been working with us.
It is difficult to work in an administration where you're required to take a position where, although something would be, in your own words, helpful, you nonetheless don't support it. Let me shift to a different topic. In the year 2013, how many criminal illegal aliens did the Obama administration release?
In 14, it was a little over 30,000.
How many murderers?
In that year, sir, I can't remember the number right now, but I know that we had the statistic that was said earlier, the 4-year period from 2010 to 2014, that there were 121 persons who committed crimes afterwards. But I can't provide you this exact number.
How many rapists?
I am not sure right now. I'd have to pull that number.
How many drunk drivers?
Same answer. I can certainly break that down for you. And in fact, I think we're working on that right now. It's been requested before.
Yesterday, how many murderers did the Obama administration release?
Now, Senator, I don't know the answer to that question, but I want the American people to understand our job and our mission, if I may. We don't release people willy-nilly. We release people pursuant to these statutes and regulations. There are only a limited number of crimes that we are required to detain people. It is mandatory. They're spelled out here very clearly, many of them related to drug distribution and conspiracies. With the rest of the people, as you know very well, Zabidas requires us to release some. I think that's a small percentage of the total. Also, the immigration courts have 500,000 case backlog. They have the proceedings they go through. They will order release because many of these folks challenge their bond or their detention. But in the rest, and I think it's like 49% this past year, in the rest where ICE has discretion, where this statute has given us discretion, we have very well-trained, very well-experienced law enforcement officers who look at the entire case just like a magistrate judge or a federal judge does.
Ms. Saldana, I want to note that your testimony here, when I ask you how many criminals ICE released in 2013, you were off by a factor of 3. You said 30,000. The correct answer is 104,000. There were 68,000 criminals, criminal illegal aliens, that ICE declined to begin deportation proceedings against, despite the fact, as Senator Sessions observed, the federal law that you're holding up there says they shall be deported. The Obama administration refused to deport them. That's 68,000. In addition to that, there were 36,000 in deportation proceedings with criminal convictions that the Obama administration released. And I would note that among those were 193 murderers with homicide convictions, were 426 people with sexual assault convictions, were over 16,000 criminal illegal aliens with drunk driving convictions released by this administration because this administration refuses to follow the law.
Sir, those numbers, I'm looking straight at them. You asked me, I thought, about 2014. That is 30,558. And the good news is, at least that went down from 2013 when it was 36,007.
But you're omitting the 68,000 criminal illegal aliens that ICE did not begin deportation proceedings against at all. And you got to add both of those together. It's over 100,000.
And yes, sir, that's absolutely right. All done pursuant to this statute that the Congress has outlined.
Now, Ms. Saldana, you heard the testimony from the victims' families. I've introduced Kate's Law in the Senate, a mandatory minimum of 5 years in prison for anyone apprehended with an illegal reentry. Does ICE support Kate's Law?
I sure would like to look at that. I haven't had a chance to. I'm not sure when it was introduced, if it has been.
It was introduced last week.
Okay. I have not had a chance to look at it. I'm sorry, Senator. But I'm certainly willing to look at any proposal along those lines and consider it and work with you if I find some objection to it.
Ms. Saldana, I will note in your opening statement here, you said after listening to the victim's family that you were so sorry for their losses. And yet the Obama administration keeps doing it. When I asked you how many murderers were released yesterday, you don't know. There is a reason the American people are upset. If President Obama had the courage of his convictions, he would come and look in the eyes of these men and women who've lost their sons, their daughters, their mothers, their sisters, their brothers, and the administration would stop releasing murderers and rapists. It is within your power to follow federal law. And this administration refuses to do so, and that is altogether unacceptable. Thank you.
It seems to me that all of us should begin as our foundational document with the Constitution. And the Second Amendment in the Bill of Rights provides that the right of the people to keep and bear arms shall not be infringed. The term, the right of the people, when the framers included it in the Bill of Rights, they used it as a term of art. That same phrase, the right of the people, is found in the First Amendment, the right of the people to peaceably assemble and to petition their government for redress of grievances. It's also found in the Fourth Amendment, the right of the people to be free from unreasonable searches and seizures. And the question that I would pose to the senior senator from California is, would she deem it consistent with the Bill of Rights for Congress to engage in the same endeavor that we are contemplating doing with the Second Amendment in the context of the First or Fourth Amendment? Namely, would she consider it constitutional for Congress to specify that the First Amendment shall apply only to the following books and shall not apply to the books that Congress has deemed outside the protection of the Bill of Rights? Likewise, would she think that the Fourth Amendment's protection against searches and seizures could properly apply only to the following specified individuals and not to the individuals that Congress has deemed outside the protection of the Bill of Rights?
Would the Senator yield for a question?
Let me just make a couple of points in response. One, I'm not a sixth grader. Senator, I've been on this committee for 20 years. I was a mayor for 9 years. I walked in, I saw people shot. I've looked at bodies that have been shot with these weapons. I've seen the bullets that implode. In Sandy Hook, youngsters were dismembered. Look, there are other weapons. I've been I'm not a lawyer, but after 20 years, I've been up close and personal to the Constitution. I have great respect for it. This doesn't mean that weapons of war, and the Heller decision clearly points out 3 exceptions, 2 of which are pertinent here. And so you know, I mean, it's fine you want to lecture me on the Constitution. I appreciate it. Just know I've been here for a long time. I've passed on a number of bills. I studied the Constitution myself. I am reasonably well educated, and I thank you for the lecture. Incidentally, this does not prohibit, you use the word prohibit, it exempts 2,271 weapons. Isn't that enough for the people in the United States?
Mr.
Do
Chairman?
they need a bazooka? Do they need other high-powered weapons that military people use to kill in close combat? I don't think so. So I come from a different place than you do. I respect your views. I ask you to respect my views.
Mr. Chairman?
Senator Durbin, it's not. Mr. Chairman, I can't add anything to that. Okay. Senator Cruz?
Mr. Chairman, I would ask yet another question of the senior senator of California. I think nobody doubts her sincerity or her passion. And yet at the same time, I would note that she chose not to answer the question that I asked, which is, in her judgment, would it be consistent with the Constitution for Congress to specify which books are permitted and which books are not, and to use the specific number?
The answer is obvious, no.
And if I may ask...
Could we keep on the, and I appreciate we have a discussion on books. I know that they have that in your state of Texas, where your educational boards tell people what books they should or should not read in their schools, something that we would not do in Vermont, but, you know, we're not going to talk about your right.
Well, yeah.
But let's stick to guns. And I know, Senator...
Mr. Chairman, I appreciate your acknowledging that the state of Texas allows books. Much of the discussion this afternoon has concerned the tragic circumstances of the Trayvon Martin case. And none of us in this hearing room were there that night. None of us knows precisely what happened. We do know that there was a violent altercation between an Hispanic man and an African-American teenager. And we know that at the end of that confrontation, the teenager was dead. What exactly occurred that night? No one in this room likely will know for sure. But we do know some things. We know that our system of justice has a process for ascertaining what happens when there is a violent confrontation, particularly one that leads to the loss of life. And that process is a jury trial. And a jury of Mr. Zimmerman's peers heard the evidence in that case. He was prosecuted in that case. And the jury rendered a conclusion. We don't know if the jury was right or wrong, but we do know that the jury system is the only system the judicial system has for ascertaining what happened, particularly when you have a one-on-one confrontation. It can be particularly difficult to determine what the facts are. But we also know that the subject of this hearing, the stand your ground laws, was not a defense that Mr. Zimmerman raised. So this entire hearing, the topic of this hearing is not the issue on which that trial turned. And sadly, we know that some in our political process have a desire to exploit that tragic, violent incident for agendas that have nothing to do with that young man who lost his life. We have seen efforts to undermine the verdict of the jury, and more broadly to inflame racial tensions that I think are sad and irresponsible. I recognize that for the family, you're simply mourning the loss of your son, and I understand that. But there are other players who are seeking to do a great deal more based on what happened that Florida night. I would note additionally that the chairman of this committee a moment ago made I thought, remarkable statement that to the effect that no one could reasonably believe that stand your ground laws protect those in the African American communities who are victims of violent crime. I think that's a remarkable statement on many, many fronts, including the fact that a great many African Americans find themselves victims of violent crime and have asserted this defense to defend themselves, defend their families, defend their children. But I also find it remarkable because the assertion that no one reasonably could suggest this benefited the African American community is drawn into remarkable relief when one keeps in mind that in 2004, a state senator in Illinois by the name of Barack Obama co-sponsored an expansion of Illinois' law providing civil immunity for those who use justifiable force to defend themselves. So the notion that stand your ground laws are some form of veiled racism may be a convenient political attack, but it is not borne out by the facts.
See, Bernie, you say wasteful, and I say people exercising free choice. You're right. We could cut costs here if we do like Europe and cut the number of MRIs, the number of mammograms. If we cut, you look at the elderly in much of Europe. The elderly here, when the elderly face life-threatening diseases, they're often treated in the intensive care unit. In Europe, they're often put in palliative care, essentially doped up with some drugs and said, well, now is your time to go.
Oh.
I don't expect the government to be saying that. And let me give, since you laughed at that, let's actually talk facts, because facts matter. Yeah. So let's talk about, for example, a couple of stories from the United Kingdom. In Glasgow, Scotland, the Queen Elizabeth University Hospital was so overburdened this past January, it turned away 3 women who were in labor,
because they couldn't take care of them. In Worcester, England, a man was left on an ambulance gurney for 5 hours before his heart attack was diagnosed. And he waited 7 hours before he received a stent and angioplasty. In a hospital in Essex, doctors twice canceled a potential life-saving surgery for a patient with esophageal cancer because there were no free beds in the intensive care unit. One more example in Wales. An 82-year-old woman who had fallen waited 8 hours on the floor before an ambulance arrived. Her daughter sat beside her in the ordeal, described it as one of the longest nights of our life. This is what happened when government takes over health care. Every example on earth. The result is rationing and waiting periods, and you, the citizens, being told, no, you can't have the health care you want and deserve.
And in America,
At that hearing, we heard testimony that described a systematic effort. If one compares, for example, the 9/11 Commission report, the word jihad appears in that report 126 times. The word Muslim appears in that report 145 times. The word Islam appears in that report 322 times. And yet, since that 9/11 Commission report, different policies have come into effect. And as a matter of systematic policy, those terms are no longer allowed to be used in this administration. The FBI counterterrorism lexicon uses the word jihad 0 times. The National Intelligence Strategy of 2009 uses the word jihad 0 times. The Strategic Implementation Plan to Prevent Violent Extremism of 2011 uses the word 0 times. The National Intelligence Strategy in 2014 uses the word 0 times. We also heard testimony from a former employee of the Department of Homeland Security, Phil Haney, that in October 2009, more than 800 Customs and Border Patrol documents were ordered modified, scrubbed, or deleted to remove references to jihad or the Muslim Brotherhood or other similar references. Was Mr. Haney's testimony that the Department of Homeland Security ordered over 800 documents in CBB altered or deleted, was that testimony accurate?
I have no idea. I don't know who Mr. Heenan is. I wouldn't know him if he walked in the room.
So you have not investigated whether your department ordered documents to be modified in 2009 to remove references to jihad, radical Islamic terrorism, the Muslim Brotherhood. You have not investigated that question?
No, I have not taken the time to investigate what Mr. Heenan says, no.
And when the United States Senate Judiciary Oversight Committee conducted a hearing on that, did you or anyone in your staff inquire into those issues?
No, but you have me right here, right now to ask questions of. So
but apparently your answer is you don't know. I am asking you, in 2009 and again in 2012, Mr. Haney testified there were 2 purges, and that was the word he used, purge, at the Department of Homeland Security to remove references to radical Islamic terrorism. Is it accurate that the records were changed?
Same answer I gave you before. I have no idea, sir.
You have no knowledge of any records being changed at the Department of Homeland Security?
Same answer. I have no idea, sir.
Would it concern you if it was accurate?
Senator, I find this whole debate to be very interesting, but I have to tell you, when I was at the Department of Defense giving the legal sign-off on a lot of drone strikes, I didn't particularly care whether the baseball card said Islamic extremist or violent extremist. I think this is very interesting, but it makes no difference to me in terms of who we need to go after, who is determined to attack our homeland. The other point I'd like to make, sir, is that, and I have to think in practical terms in Homeland Security, I think this is all very interesting, makes for good political debate, but in practical terms, if we, in our efforts here in the homeland, start giving the Islamic State the credence that they want to be referred to as part of Islam or some form of Islam, we will get nowhere in our efforts to build bridges with Muslim communities, which we need to do in this current environment right now that includes homegrown violent extremists. They all tell me,
my time is limited for this
Hold
question.
on just a second, please. They all tell me that ISIL has hijacked my religion, and it's critical that we bring these people to our side to do this.
You're entitled to give speeches other times. My question was if you were aware that the information has been scrubbed. I would note the title of the hearing on Tuesday was willful blindness, and your testimony to this full committee now is that you have no idea and apparently have no intention of finding out
That's not what
whether DHS materials have been scrubbed. And you suggested just a moment ago that it's essentially a semantic difference. Well, I don't believe it is a semantic difference, that when you erase references to radical jihad, it impacts the behavior of law enforcement and national security to respond to red flags and prevent terrorist attacks before they occur. Thank you for being here this morning.
Morning.
I'd like to address three areas, and I'd like to start with the topic you were just discussing, the topic of drones. In your response to Senator Paul yesterday, you suggested there may well be circumstances in which it is permissible to use drones to target a U.S. citizen on U.S. soil. I'd like to explore those circumstances, and in particular you pointed to two. You pointed to Pearl Harbor and 9/11, both of which were extreme military attacks on the homeland. I want to ask a more specific question. If an individual is sitting quietly at a cafe in the United States, in your legal judgment, does the Constitution allow a U.S. citizen on U.S. soil to be killed by a drone?
For sitting in a cafe and having a cup of coffee?
If that individual is not posing an imminent and immediate threat of death or bodily harm, does the Constitution allow a drone to kill that individual?
On the basis of what you said, I don't think you can arrest that person.
The person is suspected to be a terrorist. You have abundant evidence he's a terrorist. He's involved in terrorist plots. But at the moment, he's not pointing a bazooka at the Pentagon. He is sitting in a cafe. Overseas, the United States government uses drones to take out individuals when they're walking down a pathway when they're sitting at a cafe. If a U.S. citizen on U.S. soil is not posing an immediate threat to life or bodily harm, does the Constitution allow a drone to kill that citizen?
I would not think that that would be an appropriate use of any kind of lethal force. We would deal with that in the way that we typically deal with a situation like that. We would expect
with respect, General Holder, my question wasn't about appropriateness or prosecutorial discretion. It was a simple legal question. Does the Constitution allow a U.S. citizen on U.S. soil who doesn't pose an imminent threat to be killed by the U.S. government?
I do not believe that. Again, you have to look at all of the facts, but on the facts that you have given me, and this is a hypothetical, I would not think that in that situation the use of a drone or lethal force would be appropriate, because the possibility...
General Holder, I have to tell you, I find it remarkable that in that hypothetical, which is deliberately very simple, you are unable to give a simple one-word, one-syllable answer, no. I think it is unequivocal that if the U.S. government were to use a drone to take the life of a U.S. citizen on U.S. soil and that individual did not pose an imminent threat, that would be a deprivation of life without due process.
Maybe I've not been clear. I said that the use of lethal force, and I'm saying drones, guns, or whatever else would not be appropriate in that circumstance.
You keep saying appropriate. My question isn't about propriety. My question is about whether something is constitutional or not. As Attorney General, you are the chief legal officer of the United States. Do you have a legal judgment on whether it would be constitutional to kill a U.S. citizen on U.S. soil in those circumstances?
A person who is not engaged, as you've described. Again, this is the problem with hypotheticals. But the way in which you have described this person sitting at the cafe, not doing anything imminently, the use of lethal force would not be appropriate, would not be something...
I find it remarkable that you still will not give an opinion on the constitutionality.